Rent in lease. Rent is the consideration paid by a tenant for the use and enjoyment of a landlord's property. Rent may be money or money's worth. Rent, where applicable, must be certain or ascertainable. Rent is not mandatory in leases. The main feature of a lease is lawful occupation by a tenant. Whether it pays regular rent, subsidized rent, or no rent at all is immaterial. African Petroleum and Ouduni, 1991, 8 Nigerian Regular Report, Part 210391. It is pertinent to note that rent is payable in arrears unless the party agree otherwise. Types of rent. A. Ground rent. This is the rent paid on the ground itself, whether or not it is developed. It represents the value of the land. Section 5, Sub 1 of the Land Use Act 1978 empowers the governor of a state to grant statutory right of occupancy on land and also to impose ground rent for such a grant. The ground rent is subject to revision for periodic 5 years. In a traditional setting, kola nut and palm wine may suffice for ground rent. B. Rack rent. This is applicable for short-term leases. It is the economic rent payable for the land and improvement and development on the land. It is also called economic rent. It represents the full value of the property. It could be paid annually, monthly, or fixed periods. C. Premium. This is a lump sum paid in addition to the other rent. It is regarded as a fine and as such is prohibited in some states in Nigeria. Section 4 of the Rent Control and Recovery of Premises Law of Lagos State 2003. Landlords attempt to circumvent the prohibition of premium by charging rent in advance for many years. There are legal consequences for rent paid in advance. 1. Inflation. A lessor who collects money for many years' rent in advance may turn out to be at a disadvantage as the value of the money may reduce as a result of inflation. 2. Tax implications. Rent collected in advance for more than 5 years is subject to taxation as income. Section 4, Sub 3 C, Income Tax Management Act, Section 3, Sub 3 of the Personal Income Tax Act. Very important, at common law, where a lease has expired but the lessor continues to accept rent, the lessor would only be deemed to have renewed the lease on the same terms and rent as the expired lease. Rent review clause. The essence of this clause is to enable the landlord to review the rent periodically. The review is usually upwards. It enables the landlord to keep up with the prevailing market rate. This is usually because the market value of a landed property keeps on appreciating with time. The right to review must be expressed as a condition in the agreement. The landlord cannot unilaterally review the rent. A rent review clause must contain the following. A. Method of initiating the review. A notice in writing to be given by the lessor to the lessee at the time within which the notice is to be given. B. The time frame for the review, e.g. after every 5 years of a lease, and the date in which the rent review will become payable. C. The method of calculating the new rent. A perfect example is by expert evaluation. D. The procedure to be applied in the resolution of any dispute if it arises. A perfect way is by having a recourse to alternative dispute resolution. A rent review clause may be inserted in the referendum or the referendum may refer to it in the schedule. Lagos Tenancy Law 2011. This law applies to business and residential premises only. It does not apply to all districts of Lagos. The law also does not apply to premises used by educational institutions for its staff. The law does not apply to hospitals. Courts with jurisdiction. Both the Magistrate Court and the High Court have jurisdiction to entertain matters brought under this law. The determinant is the amount of money involved in the case. Where the claim exceeds the monetary jurisdiction of the Magistrate Court, the matter goes to the High Court. Rent review. The law provides that there should be no arbitrary increase of rent. The landlord cannot unilaterally increase the rent. If it does so, the tenant has the right of action in court. Rent in advance is unlawful. It is unlawful for the landlord to demand for rent in advance in excess of 6 months for monthly tenancy or in excess of 1 year for a yearly tenancy. It is mandatory for a landlord to issue receipt to the tenant upon payment of the rent. Where the landlord fails to issue such receipt, it is a gross violation of the law and is punishable with a 100,000 naira fine or 3 months imprisonment in the alternative. The landlord also has to ensure that the tenant enjoys quiet possession of the property he has let out to the tenant. In this circumstance, the law envisages that it is not a license. In a lease, the lessor must notify the lessee before entering to inspect the property, whereas it is not the case in the license. Okechukwu and Honora, 2001, FWR 208. Implied covenants in a lease. Implied covenants are covenants inferred from the agreement and the circumstances surrounding the execution of the lease. They are usually inferred by the law even where they are not expressly stated. Implied covenants on the part of the landlord includes a covenant to ensure that the tenant enjoys quiet possession of the property demised to him. B. Covenant not to derogate from the grant. C. Covenant to comply with the procedure guiding the recovery of premises. Implied covenant on the part of the tenant includes a. Covenant to pay the rent agreed upon. B. Covenant not to commit waste on the property. C. Covenant to deliver the premises in a tenantable condition. Section 64 of the Registered Land Law of Lagos State 1994. Express covenants. These are covenants agreed upon by both parties during negotiations and exchange of drafts, and they are usually expressed in the lease agreement. They often incorporate both usual and implied covenants. Express covenants are covenants which should not be implied in the lease or enforced by the parties except there is a definite agreement on them. Examples are A. Covenant on use of the property. B. Covenant not to sublet, assign or part the possession of the property. C. Covenant to insure the property. Covenants in leases. Covenants are promises or pledges made by the parties in a lease either to do something or to refrain from doing something. Basically, there are three types of covenants. 1. Usual covenants. 2. Implied covenants. 3. Express covenants. Very important, the type of covenant to be inserted into a lease agreement depends on the following. 1. The type of lease. 2. The nature of the property. 3. Practices within the jurisdiction. Usual covenants. Usual covenants are proper and common covenants in a lease. The points to be considered here are as follows. A. The purpose and usage of the trade for which the property is let. B. The custom of the locality where the property is situated. C. Previous dealings on the property. D. The type of lease in question. E. The nature of the property. Although they are proper and common, usual covenants are to be reasonable and they include the following. 1. Covenant for quiet enjoyment of the property. 2. Covenant to pay rent. 3. Covenant to pay taxes except those expressly stated to be payable by the landlord. 4. Covenant to keep the property in a good state of repairs. 5. Covenant to allow the landlord to enter and view the state of repairs in the property. User covenant. Premises can be used for any purpose which is legal, although the usage may differ from the purpose for which it was earlier rented. Covenant on use provides the purposes for which the lessee is to put the premises to, either residential, agricultural, or commercial. The importance is as follows. A. To avoid quick depreciation of the property. B. To protect neighbors. C. To prevent it from being used for illegal or immoral purposes. D. To protect the reversionary interest of the lessor. The covenant may be drafted as follows. Remedies for breach of user covenant. 1. Action for injunction to prevent a contrary use. 2. Action for damages to compensate for misuse of the premises. 3. Action for forfeiture and re-entry if it is provided for in the lease. Very important, town planning laws and regulations may affect the use of land. Covenant to pay rent. The lessee covenants with the lessor to pay the rent reserved in the lease at the time and in the manner prescribed, or paying the sum of, yielding, and paying. A lease should provide for the payment of rent because it is not one of the implied covenants in leases. Rent could be paid in money or money's worth. It must also be ascertainable. Once the parties have agreed to the sum to be paid as rent, neither of the parties can unilaterally alter it. Yahya and Chikuma, 12 Nigerian Weekly Report, Part 291, 47 SC. Almost all the states of the Federation except the Federal Capital Territory have regulations controlling rent charges in Nigeria. Remedies for failure to pay rent include 1. An action in court to recover the money. 2. An action in distress. A perfect example is the seizure of the lessee's goods to satisfy the rent without going to court. 3. An action for forfeiture when same is contained in the lease. 4. A claim for men's profit against a tenant at sufferance. Who is a tenant at sufferance? A tenant that sufferance is one who enters the premises lawfully through a valid lease agreement but stays over after the expiration of his tenure.